North Carolina General Statute 138A-15 mandates that at the beginning of any meeting of a board, the chair shall remind all members of their duty to avoid conflicts of interest under the subchapter. The chair also shall inquire as to whether there is any known conflict of interest with respect to any matters coming before the board at this time. We have 3 members here out of the 5, Marion Deerhake, Steve Keene, and myself. So we do have a quorum with about 3 out of 5. Anybody have a known conflict or anything? Hearing none, I'll assume that we don't. What we're going to have today is some informational items again, and that's what we've done the last 2 things. We've been looking at what actually can be used in NPDES, what role that has of being a national part of the Clean Water Act, obviously. So we'll ask, is it Julie going to be?
Yes, sir.
She'll be the one that will lead this and have a PowerPoint presentation, and then I'll have some comments. And if the group or the chair of the commission has comments, we'll do that as well. And I'll just to lead into it a little bit, I did ask, what is the role of the EMC as far as the NPDES is concerned? And I wanted to make sure the committee understood that. What is the role? Do we have roles and responsibilities that we haven't used? Is it something that we should be concerned about? And I'm learning myself tremendously. I could probably take a whole lot of lessons from Commissioner Deerhake and be able to understand this thing better. But the only time I've had involvement with NPDES has always been in the hog wars, the chicken wars, and the trout wars. And now I'm been involved with some stormwater through soil and water. So all those are impacted by the NPDES. So from the regulatory side, I've been on that side. So I'm proud to have you if you'll give us your informational meeting. Thank you.
Okay, good afternoon. And I'm Julie Gribb, Deputy Director for the Division of Water Resources. So I'm here to talk about the memorandum of agreement between the state of North Carolina and the EPA. Primarily, the purpose is it's administration of the National Pollutant Discharge Elimination System program within the state. It's a federal program that the state implements and the EPA oversees. And they have oversight and technical assistance. Primarily what it does, it sets forth procedures on how NPDES program will be administered. Okay? And there's a lot of details within the MOA that talk about what permits must be reviewed by EPA, how if the EPA objects, how that process would work, what review time they have, things like that. It goes into a lot of procedures. It's based on the Clean Water Act and federal regulations, and any modifications must be in writing and signed by both parties. I'll get used to using this little tool here. Okay. Okay. Yeah.
There you go.
Okay. Oh, when I take my hand off it. All right, this could be more difficult than all right, we'll see. All right, the state administers the NPDES permitting, compliance, and enforcement. We have a lot of guidance documents that EPA gives to us. We have an enforcement, a response guide. We have an NPDES permitting manual. There's a lot of modeling guidance out there. So there's technical guidance that we all use, the state uses. The exclusion to the MOA is we have no oversight over tribal areas. And we don't administer the federal biosolids program. However, we do have a state program and we issue state permits. The EPA reviews program revisions and assures federal compliance. State responsibilities. We maintain resources and a legal framework to implement the NPDES program. We issue permits from primarily industrial, municipal, and this MOA also covers the stormwater section and the other dischargers. How do they do this? We have a work plan that's called the 106 work plan, and it gives, there's agreement made on what our objectives are for usually a year or 2 years at a time. It targets like keeping the backlog down, making sure we're implementing the Clean Water Act, that we enter data into ISIS. We address any auditing issues that they have seen through the years. It gives us the number of inspections we have to do on major and minor permits. And then reporting like significant noncompliance, how we handle that. So it goes into a lot of detail in a 106 work plans. This is just discussed briefly in the MOA, but they talk about the 106 work plan if you read it. Okay. EPA's responsibilities is to provide the funding and technical assistance. They do provide training. If we ask them for documentation from other states or permits, they'll get that for us. And they have regional meetings where we get together and discuss concerns. They ensure state compliant with federal laws and regulations. Okay. The state drafts, reviews, and issues the permits. And the EPA will review many of our drafts, okay, mainly for majors, and they can object if they want to. EPA may waive review for certain permits, and for a lot of minor permits they do, but they can repeal that waiver at any time, and they have done that on certain cases. We also have to implement the compliance monitoring and enforcement. We track permits, compliance, and violations. We submit the quarterly noncompliance reports to EPA. And we take timely and appropriate enforcement actions against violators. EPA likes to verify state data. They will come down and sometimes do an inspection with us or take their own samples. They may take direct enforcement action if the state fails to act, or sometimes actually we request them to come and take action and they'll assist us in some enforcement action. They do annual audits of state MTS program. It says that in the MO, they rarely do an annual audit, but they come when they can. And then we make some changes as needed. And they review permit processing, compliance, monitoring, enforcement. And EPA, state is to notify EPA of any changes to statutes, rules, or program authority. We have the pretreatment program. That's the program that monitors industrial users that discharge to publicly owned treatment works, and to ensure compliance with the pretreatment standards and conduct special pretreatment audits, which includes going to some significant industrial users and checking out where they sample and where the city samples that it regulates them, and looking at local pretreatment permits for their SIUs. I included a slide on the Attorney General because the Attorney General plays a key role in providing legal support and coordination for our compliance group and enforcement. And the Attorney General has to certify any program changes as well because they can be so involved in our enforcement actions in this process. In conclusion, we establish a collaborative framework for administering the NPDES program. We assure compliance with the Clean Water Act and protect the water quality of North Carolina. Chair Yarborough asked me to talk about the EMC's role. It's only mentioned twice in the MOA. I don't know that there's an actual assigned role other than the overseeing or administering the NPDES program that the state has to do. It certainly plays a role in many aspects of permitting. In fact, that you adopt the water quality standards that we use to develop permit limits. You look at the basin plans, right? Special order of consent, that we did with Greensboro, that was so successful. If it's a controversial special order consent that goes to public hearing, then the EMC must approve it. Okay. Sometimes our settlement agreements with different organizations, they will write in the settlement agreement that we must present reports to the EMC and update you on what's happening related to that court case. One case in particular, variance. If a permittee comes in and wants a variance, for example, Mount Olive Pickle. If they want a variance, then it has to be approved by the EMC because that is considered a standards change. There was at one time, the EMC had a role in reviewing and potentially modifying NPDES permits, especially after initial decisions by DEQ. However, that was changed in 2023. I believe there was a regulation, and they took that authority away, and they just left it with the Office of Administrative Hearings. So the final say now is with the ALJ, and the way to go further if we go to Superior Court. Okay. And that really is all I had to present today. Anybody have any questions?
Yes. I've got a question. Thank you, Julie, and thank you, Mr. Chairman, for putting this together, Mr. Chair, on NPDES. That's certainly a subject matter that is coming across the radar on the Water Quality Committee in reference to many things that we're going through at this time, trying to get some direction from EPA. So thank you, Julie. That was a good overview. You mentioned regional meetings. As we all know, we've going through another administration now in November, and then Region 4 being on the EPA piece closest and working through that director and regional meetings. You mentioned regional meetings. So has there been any regional meetings that the department, that DEQ has been a part of in the last 6 months since the new administration has taken over and Region 4 has changed some new faces? Have we been available?
We've had meetings with different EPA staff, but to my knowledge, there's not been a regional meeting that I'm referring to where all the states get together with EPA. No.
But regional meetings, is that where the region gets together? Help me
A regional
understand
meeting
the
to me,
regional
my
meetings.
reference was when all the states in Region 4 gather with EPA staff, upper management, and have discussions on concerns in their state or different programs. Okay, we have not had that meeting in the last 6 months.
Gotcha. Okay. Building relationships, though, Mr. Chairman, I would think that would be important to find, what their direction. You had mentioned the guidance on MOAs and 106 work plan and where we are with this new administration in Region 4 and how if we have questions and concerns that we have that relationship, building that relationship. And that's what I thought that was being brought about by regional meetings, is to be at the table with Region 4. Do we have inroads through the department to Region 4?
Okay.
Yeah. So we stay in pretty regular contact with the region, the staff of the region. As Julie mentioned, they do have regional meetings with all the Region 4 groups coming together. We had one scheduled. I think we were trying to look in June and May. That got canceled. Currently, there's an online meeting that is being scheduled for the end of this month or in August at some point in time, where the water quality director for Region 4 will get with the programs in the 4 different regions, or the states in Region 4. So that is ongoing. They're working to get through that. And so we are working with them as closely as possible, make sure we'll attend that and begin that dialogue.
Will we be notified of that meeting? Are we able to go? Mr. Chairman, are we able to go as commissioners just to attend, gather information, or would that be a conflict?
Can't imagine it being a conflict. If that's something that you want to do, I don't know that you can be directed to, but you could, I wouldn't have any reason to not believe that you could not attend.
Well, it is for the programmatic areas. And I don't know whether folks outside the programs typically don't attend.
Okay.
But it's typically for directors, like our group that goes are our Director of Water Resources, Julie, Michael, and I, the deputies. And then we also take along public water supply. And if there's any additional topics of interest, specifically to stormwater and things like that, Toby would be engaged. But it's typically just the directors from the different states in the region that attend.
Okay, thank you.
Yes,
Thank you, Mr. Chairman. Allow me to speak.
Yeah, that's interesting too, because the MOU does list EPA, the commission, and DEQ, as you mentioned. I only found it once, but you said it was in there twice. And so that's the purpose of this, is to find out what is the commission's role. If Commissioner Keen would want to attend such a thing as that, I guess it'd be up to him to do so. I do have some concerns.
Let me fill in. I mean, I think at bottom line, from the state standpoint, statutorily, and it's cited in the MOU, it's 143B 282-1 expressly gives the power to the EMCs to grant a permit or temporary permit, to modify or revoke a permit, or refuse to grant permits pursuant to other state laws with regard to controlling sources of air and water pollution. So we are the body statutorily that's been given the power to do this. Now, we have delegated that by rule over, but that still doesn't eliminate us in the state statute from being the body ultimately responsible at the top of the tree for doing that. So we could talk about that and figure out the logistics of that and the relevance, but I don't think there's anything to preclude a commissioner or you, Commissioner King, from going but we could run that up the tree and see what it would be. But I don't see anything in law that would prohibit you from going.
Yeah, and I think the primary aspects of the MOU, if I've written this right, is to issue, reissue, modify, terminate, or deny NPDES permits. That's pretty much bottom line, isn't it? So, and you already mentioned that we do have some responsibilities, but through the collaborative approach through all the other pieces of the department, not specific to this, but in little pieces of it. So that in reality, the EMC does have some role. I don't know that we've ever used it. In the past, I think that, as you mentioned, they had those reviews, and I certainly would not want to be doing those all the way through. I can't imagine how much work that would be.
Well, and I think that's fair, because I think probably Commissioner Deerheck remembers the days where the EMC met for 2 days and did grant some permits like this, and it was a lot of work way back in the day. But of course, if you look at your rules that are coming tomorrow, we delegated this at an EMC years ago to the department to do the actual rule issuance and stuff. It didn't take us out of it. We're not expressly out of the statutory requirement to do our duty, but those rules have not been revisited in 20-some years now. And that's what we'll be talking about tomorrow, those A rules that weren't reviewed last time, but need to be reviewed this time. And this MOU dates to 2007. So coming up in 2 years, this MOA has not been popped open in 20 years. So, part of this today is to say, what are the statutory authorities that the EMC may have? What are our duties and roles? And should we just y'all have heard me say that in previous meetings, should we just be throwing NPDES permitting over the wall as we did maybe 20 years ago, and not ask, should we be back involved at certain points, or is there a role for us back involved? And again, as a commission, I think it's pretty squarely stated that it is our duty to do this, and how much we delegate is up to us, or maybe ultimately up to the General Assembly, how much we delegate.
And I can imagine, going back to the trout permit, it might have been some help if they had an opportunity to overcome some of this, because can the state, can you make new laws, new rules, incorporation at state level just on your own? I think that's where we're at. Could it have helped? Could it have got rid of some of the angst possibly if we'd had that opportunity? I don't know.
Well, I do think it did help. And if you remember, we talked previously in other meetings that one of the things I saw when we started talking about this issue about a year ago was the General Assembly is inserting us in these matters now when they get frustrated between the applicants and the whatnot. And so I'd much rather be part of the process as we go forward in collaboration with the department to help all the parties out where we can or where we think we relatively should, and have somebody go to the General Assembly to go have us written into something to get involved in it. I think there's a clear role in the statutes that we should consider as a commission of how much we should be in or out of this process.
And I think too that, and I asked that when we had our conversation the other day, it's plainly stated that state and MOU with EPA. I interpret the EMC, and I think that you agreed that the EMC is part of the state. It is a state as a part of the general statute. So we do have some responsibility there. Commissioner Deerhead.
Well, I'll point out that the conditions of the MOU are that they are signed by the regional administrator of Region 4 and the director of the Division of Water Quality, not by the EMC.
That's correct.
It's the director's discretion whether or not to sign this MOA. And so the director is responsible for the contents and judgment of what's appropriate and what's not. So I do want to point that out. The EMC does not vote to direct the director to approve it. It's my understanding, the way I read it. Maybe
That's a good
the
point. That's a good
council can
No.
clarify if she thinks it's a little different from interpretation.
I mean, I certainly don't want to say anything that's incorrect or that would be official. I think, and the MOA does certainly incorporate the EMC, even if only signed by the director.
Right. But ultimately, it's the responsibility of the director to sign it and to judge whether or not the content's appropriate and feasible. But
Where
the
we
only
may
other-
disagree, Commissioner
Mhm.
Deerhake, if I may, we have a process already for declaratory rulings. When the department applicants think the department on something is enforcing something that's not right. And we've done that for air in the past year or so, but as the rule maker and the policy setter, we are a part of appeals process already by applicants for declaratory rulings. So I don't think what anybody would suggest is we're directing the department to issue a permit or not, but we may be called in, like the chair just mentioned, in the trout stream controversy or something, to try to help mitigate between the parties about what the EMC means by a rule that we have to establish, not the department. So I think there is legally, you could look at that and say, we are the rule maker and they're the enforcers. I don't think they're the interpreters necessarily. I think we're the interpreters. But that's my opinion. That would be something that courts could work out.
And I will just say, based on my experience, the majority of the time, I think I've been on this committee since I've been on the commission. The department does come to us for certain circumstances, variance requests. We had an EIS-related matter with the Carolina Hills splitter, I think over near Charlotte, that required some action by this committee. And it demonstrates to me that the technical understanding needed to complete a permit and execute a permit with the permittee requires a great deal of time and attention and expertise, knowledge of the subject, the site specifically, in order to develop the terms and conditions of those permits. And I think you will agree that the EMC does not want to get into the job of reviewing each and every permit and specifying the terms and conditions to the staff to write into the permit. It's very exceptional cases when it comes to the EMC.
I don't think the EMC ever wants to get back in the process of writing permits. I don't think the department has enough permit writers like it is. I don't think we can
Well, I'm
we can
glad
stay
you
at Holiday
agree.
Inn and be them ourselves necessarily either. So
I'm
I
glad
like to
you
pay people. And I don't think we're trying to direct anybody as much as be part of a process where we may have a duty to be part of a partnership process here. So that's all I'm saying. I don't think we're trying about directing anybody.
And Mr. Chairman, one other observation I wanted to make is we've been talking a lot about significant industrial users for a good while now in pretreatment programs, and there is specifically a section in the MOA on pretreatment. And I think that there's clear explanation in here of what the department's role is And I think the conditions support the position that I've been advocating for a while, is that the department needs to play a more active role in the delegated authority to the division, to the local programs. And when I mean more active role, I mean periodically checking in with them, maybe every several years, performing an audit of each and every pretreatment program. That's something that's done with the Sedimentation and Control Commission programs. We have regular presentations on audits conducted by for local programs, and with what we've experienced in the past 2 or 3 years with dioxane, for example, I don't see that the Division of Water Resources is regularly going in systematically auditing. Can you tell me how that works with program evaluation?
So we go at least 3 out of 5 years, every 5 years. We go do an audit, either a formal audit or at least an inspection on their pretreatment program.
Oh, that's good to know. I never knew that.
We also review all their local permits
Mhm.
before they're issued to the SIUs, review their local ordinance, and any changes to their programs.
Well, then I think it would be helpful for this commission or committee to periodically hear updates about your audit findings. For the Sedimentation Control Commission, they actually are in a position where they can decide whether or not to continue the local delegation. I don't know whether the EMC is authorized or tasked with doing that. Do you know, have you ever had to come to the EMC and ask for?
No, we have oversight of that delegation, and so I would assume we can repeal it if we can justify that repealing it.
Okay.
I don't know that we've ever had to, but we would take enforcement first against the town or the city.
Mhm.
At least we would take legal action first to get them to do their job and then pursue it from there.
Well, then I would encourage maybe a periodic report to the EMC of how those audits are going, as those program assessments are going. So that if something like this comes up again with dioxane or any other effluent limit, that members will be more informed as they go into their decision-making.
And,
And I agree
and
with that. I think that'd be very helpful. I think that in a way, I go back to the stormwater. My very first meeting here was, we approved some stricter stormwater rules. Well, there's a lot of towns that that's tough. The definition of a town is very different in certain parts of it may not even be a village, or it's very small and they're still having to do a lot of stormwater work. Well, that's a good thing. The other thing I was going to ask is, since you've declared that EMC is a member of the state when it says state and EPA in this MOAs, would you still agree to that? It's part of the state. Both of you looking at me, yeah, I'm not sure about that. Well, okay, let's figure that out first then. It is part of the state. Absolutely. Okay, yeah, that's good. That's what I wanted to do. If somebody did want to have more involvement in the EMC, would you be able to, or would that require a rule, or would that take legislation?
I don't think it would take legislation by any means. I think it would be incumbent upon the department, the EMC, to get together to talk about what those issues are, that, like the pre-treatment audits, updating there, and continue and try to see how we can continue and better communicate our permitting, controversial permits and those kinds of things with the commission. And then if things ramp up or we need to consult and go through for variances or address through SOCs and things of that nature, work with the commission through that way. That's the way I would like to pursue it. And I think it is important for y'all to be informed, and it's not good for y'all to get a call. Nobody likes to call from the legislature, but it would be good for us to set forth some framework that we can come up, give y'all general updates on NPDES permitting, audits and things of that nature. Would be glad to work with you in this committee on doing that and with the whole commission.
Yeah, and to speak from the whole commission, we talked about this, I say last year, it seemed like it was last summer, but we had one party that came in and suggested controversial permit review like Virginia had at one time. And that's what we're talking about, what's controversial. We don't want to look at every one of them, but if there's some controversial and can help mitigate that or interpret that, we should be able to do that. And then I think we talked about at that time, it would be nice on a regular basis to get a list of even the NPDES permits of all kinds that are being issued. They're on the website, I know,
Yep.
but to have we don't need just a list. We need to say, these are the controversial ones as we talk. But I think we can work through that either by rule or agreement or statute. We can get through that.
Yeah, we do want to keep a degree of separation.
Yeah, so Virginia has a very formal process, and it's part of their OAH process
Right,
that you go
understand.
back and discuss controversial. They just don't discuss them while the permit's being developed. It's after the permit's developed and drafted, and then the permit is contested.
Right.
Okay, so that's when they get, but we had that authority in this state, and it was taken away.
Right.
Just so you're aware, that's how that went down.
Yeah.
And I don't know that the
It's not exactly right. I think, and I'm not being argumentative, but I think a lot of that got passed directly to OOH to decide these permits that were issued, people had complaints. They didn't have to come back to the EMC to look at permits that had been issued. And I'll have to go back at the documentation of that. But it did give some post thing. I think we're still talking about pre things now as the permit's being developed and people are looking for interpretation of the rule or what can be in a permit. That's the part where that was what was delegated to us by legislation that we passed to the department. There's no requirement for a necessary firewall there to interpret what the rules or statute says. I'm not sure that, I'm not trying to be argumentative with y'all. I don't think y'all are the interpreters of the rules. I think we're the interpreters of the rules. So that's just my opinion. So.
I'd just say a couple of things just based on long history with the APA side of this. I mean, the department's correct that for many, many years, the EMC was the final agency decision maker on permit appeals. And so the department made a decision. If it was appealed, then this commission actually made the final decision after a contested case hearing. The General Assembly took that power away, created the Office of Administrative Hearings. So one thing just to keep in mind, and I think it's important wherever this goes, to understand there need to be some very clear guidelines and rules for whatever it is this commission is going to do. But there are already legal limits on what that can be. It cannot be anything that looks like a fact-finding hearing that takes in facts outside the permitting record and makes a decision. I mean, the Administrative Procedures Act makes it very clear we cannot do that. We have processes for doing interpretation, whether through a declaratory ruling or we do variances, obviously. So there are ways for the commission already to formally provide guidance on interpretation. So just a note that wherever this goes, it has got to be formally described, and it has to be within the limits of what the General Assembly actually allows this commission to do. The one other thing I'll just throw out there in terms of who the state is in this situation, traditionally in these types of agreements with federal agencies, the state means the governor and the governor's executive branch agencies, because they're the agencies who are implementing these programs. In the last few years, as the General Assembly has changed the makeup of a number of state boards and commissions, we now have a much more complicated landscape, because previously, although the governor's office never dictated the position of every commission member, previously the governor appointed a majority of the commission members and the chairs. And so there was not the same degree of conflict potential between the EMC and the department as has developed over the last few years. There's now no longer sort of a unified governor's executive branch entity for EPA to deal with. And so I think you just have to recognize that things have changed, but from EPA's point of view, I think for years and across multiple programs, they read the state to mean the governor and the executive branch agencies because they take into consideration the legislature's role in the fact that the legislature adopts the laws that we operate our programs under. But when they're dealing on an administrative level, that's where the interaction traditionally has been through the governor and the governor's appointees. So it's just more complicated now.
Yeah, and I appreciate those comments. The main thing that I wanted to be able to describe in this meeting is what is a responsibility so the committee will know. The second piece of it is if you get a question in the public, and as some of us do, there's always somebody ought to fix that. Well, I always look at them and say, well, you're somebody, why don't you fix it? So we need to be able to say to some folks, we have limited powers with the EMC, if that's what we're going to say. On the other side of it, if the legislature asks us, what do you need to make changes? Then we need to know that too. And that's part of what your comment, both of your comments are. What is it able to do? And that's all I ask for. We're not trying to debate whether we want to do this. It's just a matter of fact is there ever an inclination? Do we have somebody that wants to appeal? Where do they go? And I think if we can, as a commission, all 15 of us will have those answers so that we can talk to people intelligently or call our legal or call Richard. We're all in the same boat. Who does what? And that's the reason I kept saying, what's the state? Your explanation's one, your explanation's another. But I assume that if it's as part of the state agency and that's what it's directed to do and they have a commission behind it, then that is part of the state. So that's my opinion, what it's worth, and I'm somebody, so I've said it. Now, go ahead, Julie, I'm sorry.
If I may, every permit writer signs their name to a permit. Every supervisor signs their name to a permit, as the director may have to if it's a controversial permit. If the EMC is making the decision for a permit writer, they will be called to court for that permit.
Absolutely, I
Just-
understand
You
that.
have to understand that.
No, I understand that. It's part of become part of the defendant. Yes, sure. That's another piece of it for us to understand.
Sure.
Okay. From the comments from the committee.
Just a quick comment in response to unified efforts to accomplish an end, to find solutions. And there's been a couple of subject matters that's been brought up in the last 15 minutes in reference to some of the items that we're looking at, particularly water quality and session law and legislative branch and the governor's branch and the appointments, which I hope we can have full appointments, hopefully by the end of July. It'd be nice. But all the appointments being from the governor's office, the House and the Senate, but when you have session laws that you are directed by the General Assembly to do as we have been done, which we will see in our following committee meeting today on water quality on the flow, you'll see that the session law is dictating the EMC. And then when you dictate to the EMC that this has got to be done, and you start doing your homework, and I appreciate the history lesson on the administrative part. But when you start doing your homework and you have to lean on different agencies and you want to know what EPA is doing. And with a new administration and with a new regional when this new region, and we're talking about building relationships and knowing what these pieces are going to be pushed down or sent down or allowed for North Carolina to take advantage of to better our state, then we have to be involved, Mr. Chairman, in some fashion. And that's how I'm taking it from the water quality piece, is that we have to see every lane opened, but we have to focus back on what the federal government is thinking, what they are doing and what they want our state to do, whether it's through a memorandum of understanding, a memorandum of agreement, or with the director's office, which ultimately falls under the secretary, which ultimately falls under the governor's appointee in his cabinet. We've got that. But the EMC does have a place. And our position is rulemaking. So as we look at these different rules that we're having to put together, then I hope that everybody can be at the table. Thank you, Mr. Chairman.
Commissioner Deerhake, any final comment?
Thank you.
Chairman?
Yeah, the only thing, a couple things. One is I heard what Commissioner Deerhake said, and I think we do have some outstanding pretreatment programs and organizations in the state. And I would like to hear more from both the department and invite a couple of those programs in for the full EMC for information sessions. They really do, yeoman's work. I was with local government for a while, so I know a little bit about how seriously they take it. I think in some ways, wastewater comes out of a enterprise fund, so there's dedicated funds for that. There's also federal felony charges for people that violate certain things there that you don't always see in stormwater. They take it very seriously, and there's some very good pretreatment programs in the state. So I think we need to see more of that. I agree with Commissioner Deerhake, and let them talk about their strengths and weaknesses and what they may need us to do too. The other thing is, I thank you for bringing the MOA up. We've heard about it. We haven't really talked about it as a body, a committee. So that was my part about today. Was it'd be great just to go through the MOA and make sure we've all read it, and we have. It is 20 years old. The delegation authority is 20 years old. I think people have said it's a little more, maybe the landscape seems a little bit more complicated these days, but certainly after 20 years, it seems like we ought to look at that stuff and say, is it still right on target or not? And I'm not saying it is or it ain't, but we just need to.
Be nice if it said DEQ too.
Well, it needs to say DEQ at some point too, probably. It still says DHNR or whatever it says in there. So.
Yeah, just on the MOAs, we've looked at the Region 4 MOAs that are currently in place. The oldest one in place is 1978. And the most recent one, I think, is 2020.
Yeah.
1978, 2020 have very little different. So they're very similar. Requirements are very similar. So
And I'm sure
it's
y'all are
almost
looking at
word
them.
for
We're
word.
just not
Yeah.
looking at them. So we need to look at them. So.
And also, I think it's important for us to understand too, I heard air quality today that very much concerned about the reduction in federal dollars. Is this going to be an impact as well? And that's another piece. It's not on the agenda, but it's a piece I wanted to bring up.
So, yes, it's very much on our minds. We have 450 positions, 190 of them are federally funded through EPA. So we are over 40% of our staff is directly funded through federal grants. So it is a big concern for us. We're already planning a meeting. It looks like reductions are coming. We don't know the specifics on that yet. But it will impact our program, and we'll see reductions coming most likely.
Well, that's one of the pieces I wanted to bring up is that we're going to have to figure out a way to support this program, period. I mean, is there other ways? And that may be our place as part of the state, that we're actually going to have to do something if we're going to continue these programs. I can see this as an issue across the board.
Yeah.
I wanted you to make a comment on it.
Absolutely. So we'll keep y'all apprised of that as we move forward and as we learn more. So thank you.
Thank you. Chairman, any other comments? Thank you for your time. Again, this is all about information. We've got to learn what our places are. And it's likely that it's going to very much change with the change in administration, the budget. We don't have a clue about what is going to actually happen. We may need to do some other things. And when somebody says somebody ought to do something, it could be us this time. So keep that in mind. This meeting is adjourned. Thank you. I warmed it up for you, brother.